Pro bono costs are costs awarded by the paying party to the side where the representation has been provided completely free of charge. It is possible to have split orders. So for instance, in the cases that I've dealt with, a client may initially have received some advice under a legal help or perhaps even a certificate. Those costs would remain payable by the legal aid agency, but at any time that or for any work that is not specifically covered by legal help or a certificate, those costs can be transferred over to pro bono costs and sought under the pro bono costs order. So you can have a split order which says that from date A to date B, costs are payable by the legal aid agency under the legal aid certificate or under a standard inter partes rate, and then from date C to D, where the work was done on a pro bono basis, the pro bono cost order will kick in and those costs will be payable to the Access to Justice Fund under the terms of the pro bono cost order. Well, the court can award the total amount of the cost claimed, and it's always at the usual market rate. So the beauty of the pro bono cost order is that you are in exactly the same situation as you would be with a private paying client. Well, in my view, where you have in my line of work, where you have a landlord who is pursuing a case and the merits are perhaps doubtful, but there is no sanction for losing against an opponent who doesn't have the ability to pay for advice or the benefit of a legal aid certificate. In my experience, that landlord will pursue the case because, in effect, they have nothing to lose. I mean, the benefit of a pro bono cost order is that if a landlord, be it a private sector landlord, a social landlord or a local authority, are aware that at the end of the case, if they're not successful, they will have the same liability to pay costs as they would in any other situation on a standard basis, that is more likely to focus the minds, get them to focus on whether or not this is a case that they should be bringing, they should be pursuing, and it may well be that the threat of a pro bono cost order at the end of the case will lead to an early settlement or the discontinuance of the case altogether. The benefit of seeking a pro bono cost order is because as a charity, any costs which under the legislation must go to a prescribed organisation, in this case the Access to Justice Fund, we have an informal agreement with them that they will then return 50% of any costs recovered to us. So there is, of course, a financial benefit to us of taking on these cases where we can recover costs. Of course, it's not the primary purpose, but is of course a massive bonus for us as a charity to be able to recover 50% of those costs. Without the pro bono cost orders, the work would be completely free of charge and we wouldn't be eligible to recover any monies whatsoever. Having advised the client of the outcome, the next step was to contact the Access to Justice Fund and make them aware that we had successfully concluded the case and that damages had been awarded and that a cost order had been made, and that as soon as a sealed copy of that order was available, it would be sent to them for their records. Well, first of all, Familiarise yourself with the pro bono cost order regime. The starting point is Section 194 of the Legal Services Act 2007, which sets out what the powers are and what work is covered. Have a quick look at CPR. CPR 46 deals with the court's powers to order pro bono cost orders. And there's some very helpful guidance produced by the Access to Justice Fund, which you can download, which gives some very helpful tips about how you advise a client in client care letters about the pro bono costs, how you might write to opponents, setting out your potential ability to recover costs on a pro bono cost basis. There are also some very helpful guidelines about making offers and very importantly some guidance about how to word any final agreements or settlements to incorporate an order for costs to be paid on a pro bono cost basis. Certainly my experience has been that there is a degree of, there's a freeing up of being able to do pro bono cost work, knowing that there is a possibility that you'll be paid for your time and your efforts. It's incredibly rewarding per se, being able to do work for a client in order to ensure that they have good representation. And the reward of bringing a successful case is of itself very gratifying. If you add on to that you will be paid for that work, and that money will go to the Access to Justice Fund, which is then redistributed to various good causes. It all adds up to making it a very rewarding and worthwhile endeavour to do as much pro bono work as you possibly can, fit in your ordinary working life.